Imagine this for a moment. You are going through your mail like any ordinary day when you notice a certified letter from the U.S. government. You open it expecting routine paperwork, but instead it says you did not report a foreign bank account. The notice lists a possible penalty of $30,000. Your U.S. bank accounts are temporarily restricted. And if you are a green card holder or someone applying for citizenship, your immigration case could suddenly face review. All of this because of a small account overseas you rarely use, maybe one you opened many years ago, maybe one with only a few $1,000s in it. Now let me be clear from the beginning. This is not a frightening story intended to alarm you. It reflects the type of situation that could become more common as financial reporting systems continue evolving in the coming years. And if you are over 60 years old, a green card holder, or someone who was not born a U.S. citizen, financial reporting rules may affect you more than you expect. Many people assume that if an account is small, inactive, or located in another country, it does not matter. They assume that because they have filed taxes honestly for years, they are safe. But financial reporting requirements can change, and those assumptions may not always hold true. What once went unnoticed might now be reviewed more carefully. What once seemed like a simple misunderstanding could sometimes lead to additional questions, reviews, or requests for clarification. The good news is this: if you understand the rules and prepare properly, you can protect yourself. You can reduce the chance of penalties, you can lower the risk of audits, and you can avoid unnecessary complications with your immigration status. By the end of this video, you will understand how foreign financial reporting rules work, why they can affect seniors and immigrants differently, and what practical steps you can take right now to stay compliant. So take a moment to relax. You are not in trouble. Learning early simply puts you in a stronger position. Hi, I am Sofia. For many years, I have helped seniors, immigrants, and green card holders better understand U.S. financial and immigration requirements that can sometimes feel confusing. I regularly work with people who are retired on fixed incomes, individuals supporting family members abroad, and those building stable lives in the United States while trying to follow every rule correctly. I understand how stressful it can feel when you are already managing retirement planning, medical costs, or immigration paperwork. The last thing anyone expects is for an old bank account in another country to suddenly become a complicated financial question. Most of the people I speak with are not trying to hide anything. They simply did not realize certain reporting rules existed, or they believed those rules did not apply to them. That is why understanding financial reporting obligations is so important. The challenge is not dishonesty, it is lack of awareness. Unfortunately, government guidance is often written in technical language that many people never read until they face a problem. My goal here is different. I am not going to overwhelm you with complicated legal terms. I am not going to talk down to you, and I am not here to frighten you. I am here to explain how these rules work, why they matter, and how you can protect yourself step by step. Nothing more and nothing less. Over the next several minutes, I will walk you through how foreign account reporting works, who it can affect, why seniors and immigrants sometimes face additional questions, and what actions you may want to consider taking today rather than waiting until future tax seasons. If these rules apply to you, you will recognize it. And if they do not, you will have peace of mind knowing exactly where you stand, because understanding the rules is one of the best forms of protection. And knowing this information today could help you avoid a financial or administrative headache that is completely preventable. So let us begin by discussing how foreign financial reporting works, because that is where everything starts. Each year, U.S. taxpayers may be required to report certain foreign financial accounts depending on their total value and other factors. These requirements are not new, but awareness of them has grown as international financial information sharing has expanded. For many people, this is simply another part of staying compliant with tax law. However, confusion can arise when people do not realize that certain accounts qualify as reportable assets. One important concept to understand is reporting thresholds. Under current rules, if the combined value of certain foreign financial accounts exceeds $10,000 at any point during the year, a report known as an F-bar may be required. For many people, this threshold means the requirement never applies. However, Even smaller accounts can become relevant when combined balances exceed reporting limits. Think about what this means in practical terms. An account with a few $1,000s that you have rarely thought about could still matter if it is part of a larger total across multiple foreign accounts. A modest savings account in your home country used for family visits or emergencies might contribute to that total. Even if the balance only exceeds the threshold briefly during the year, reporting requirements could be triggered. What surprises many people is that reporting is based on the highest balance during the year, rather than how much income the account generates. For example, if money was deposited temporarily or a payment increased the balance for a short period, that highest value may still count toward reporting calculations. Another area that creates confusion is the definition of what qualifies as a foreign financial account. Many people think only of standard checking or savings accounts. In reality, the definition can include several different financial arrangements depending on the circumstances. Certain retirement accounts, investment accounts, or insurance policies issued outside the United States may sometimes be considered financial accounts for reporting purposes. In some situations, prepaid cards, digital wallets held with foreign institutions, or financial interests connected to property or businesses abroad may also need to be evaluated. In simple terms, if a financial asset exists outside the United States and holds measurable value, it may fall within reporting rules depending on the details. This is particularly common among immigrants or seniors who maintained financial ties to other countries long before they moved to the United States or before they knew these reporting rules existed. Many people hear this and think, that is not really an account, it is just something I have always had. But from a compliance perspective, what matters is the existence and value of the asset, not how casually it is viewed by the owner. That is why some individuals are surprised when they discover that several small assets together exceed reporting thresholds. When a modest savings account, a small pension fund, and an old insurance policy are combined, the total may reach levels that require disclosure. Before you feel overwhelmed, it is important to understand another development that has influenced financial reporting in recent years. Government agencies today exchange information more efficiently than they did decades ago. Historically, information about financial accounts could remain in separate systems and sometimes took longer to reconcile. Today, digital systems allow data to be compared more quickly across different records. That does not mean mistakes automatically lead to penalties, but it does mean inconsistencies are easier to identify and review. For example, if a foreign bank reports account information through international agreements and that information does not appear on a related tax form, authorities may request clarification. If a taxpayer indicates that no foreign accounts exist but financial data suggests otherwise, it could prompt questions. For individuals applying for immigration benefits, financial compliance may also be reviewed alongside tax records. This does not mean that every issue leads to enforcement action. In many cases, it simply results in a request for additional documentation or explanation. However, it highlights why accurate reporting matters. In the past, some people assumed inactive accounts or accounts opened many years ago did not require attention. Today, those assumptions may not always hold true. If a financial connection exists and reporting requirements apply, disclosure is generally expected regardless of how often the account is used. At this point, many people ask the same question. Why do seniors and immigrants often appear in discussions about foreign financial reporting? The answer is mostly practical. Studies have shown that individuals whose lives span multiple countries are more likely to maintain international financial ties. Seniors may have worked abroad earlier in their careers, retired overseas for a period, or maintained accounts established decades earlier. Immigrants frequently keep financial links with family members in their home countries. They may support relatives, maintain retirement savings abroad, or share ownership of family property. From their perspective, these assets feel separate from their lives in the United States. Under U.S. law, however, worldwide financial assets can still be relevant for reporting purposes. Because of this reality, compliance discussions often focus on these groups. Understanding the rules early can prevent confusion later. Once reporting systems identify missing information, individuals may have fewer opportunities to correct simple mistakes quietly. Preparation is therefore the most reliable protection. In a moment, I will explain how these requirements can affect different groups of people in different ways. But first, I want to pause briefly. If this information is new to you, or if it makes you think about reviewing your own financial situation, consider liking this video. That small action helps more seniors and immigrants learn about financial reporting requirements before problems arise. These topics can be complicated, and clear explanations help people stay informed. Thank you. Now let us talk about how foreign reporting requirements can affect different groups of people, because the impact is not identical for everyone. Many individuals over 60 who were born in the United States assume these rules do not concern them. They believe international financial reporting only applies to immigrants. That assumption can sometimes be inaccurate. If a person over 60 has financial connections outside the United States, those assets may still require disclosure depending on their value and structure. Examples include receiving a pension from work performed overseas, maintaining a bank account abroad for travel, or owning a portion of property or investments in another country. What has changed in recent years is the level of detail requested on tax forms. Questions about foreign assets have become more visible and more specific. The purpose is to ensure taxpayers consider whether they have international financial ties that require reporting. Even accounts with modest balances can matter if they contribute to totals above reporting thresholds. A dormant account or a joint family account may still require disclosure if the person has access to it. From the perspective of the reporting system, the key principle is straightforward. If a foreign financial connection exists and reporting thresholds are met, the information should be disclosed accurately. Guessing or skipping questions can create confusion later. For many seniors, this situation feels strange because these accounts often represent distant parts of their lives. Perhaps something created decades earlier and rarely used today. Yet reporting rules focus on the existence of the account rather than how emotionally important it feels. The next group facing unique considerations is green card holders. For lawful permanent residents, financial compliance is closely linked to immigration history. Green card holders are required to follow the same tax reporting rules as U.S. citizens. When a green card holder later applies for citizenship, immigration authorities typically review tax compliance as part of evaluating good moral character requirements. This review may include checking whether required forms were filed and whether tax information appears consistent. Even if a reporting mistake was unintentional, it may lead to requests for clarification, additional documents, or extended processing time. It does not automatically mean an application will be denied, but unresolved issues can slow the process. That is why many advisors recommend addressing financial reporting questions early, rather than waiting until a citizenship application is submitted. Taking action sooner gives individuals more control over the situation. Waiting until a review begins can make corrections more complicated. Naturalized citizens sometimes assume these topics no longer apply to them after receiving citizenship. In reality, U.S. citizens, regardless of birthplace, must follow the same tax reporting rules. If they maintain financial connections outside the United States, those assets may still require disclosure depending on reporting thresholds and applicable regulations. People who were born abroad often maintain international ties longer, which is why they sometimes encounter these reporting discussions more frequently. Finally, individuals living in the United States on work visas, student visas, or other long-term statuses should also pay attention to tax obligations. If they meet the substantial presence test for tax purposes, they may be treated as U.S. tax residents. That means filing U.S. tax returns and following reporting rules for foreign accounts when thresholds are met. For those who hope to apply for permanent residence or citizenship in the future, maintaining accurate tax records from the beginning can prevent issues later. Financial compliance therefore becomes part of a larger long-term plan. Now let us shift from discussing risks to discussing solutions, because this is where people regain control. Instead of worrying about potential problems, the smartest step is to organize your financial information early. Consider this your action plan. Step 1 is creating a complete list of your foreign financial connections. Write down every foreign bank account you have access to, including those with small balances or those rarely used. Include retirement accounts, pension funds, investment accounts, or insurance policies issued by foreign institutions if they hold cash value. Also list any ownership interests in foreign property or businesses that might generate financial returns. For each item, record the institution name, country location, approximate value, and whether the account is held individually or jointly. Gathering this information early helps prevent missing details later. Step 2 is reviewing whether foreign account reports were required in previous years. If the total value of foreign accounts exceeded reporting thresholds in the past, certain forms may have been required. Many people discover these obligations only after learning about them later. If that happens, it does not automatically mean penalties will occur. In many situations, voluntary correction procedures exist for individuals who made honest mistakes. However, ignoring the issue is rarely the best choice. Addressing it early usually leads to better outcomes. Step 3 is preparing documentation for future reporting if necessary. This includes collecting bank statements, balance confirmations, and records showing the highest value of each account during the year. When accounts are located overseas, obtaining these documents may take time, particularly if language barriers exist. Starting early reduces pressure later during tax season. It may also be necessary to convert foreign currency balances into US dollars using appropriate exchange rates. Keeping records of those calculations ensures consistency if questions arise later. Step 4 involves accurately reporting foreign income when required. Some individuals receive pensions or other payments from abroad. Even if taxes are paid in another country, U.S. tax law may still require reporting that income. In some cases, tax treaties help prevent double taxation, but disclosure is typically still necessary to claim treaty benefits. Step 5 is maintaining organized records. Save copies of tax returns, foreign account reports, bank statements, and supporting documentation. For green card holders or future citizenship applicants, organized financial records can simplify immigration reviews. Many delays occur not because someone violated rules, but because documentation cannot be easily located. Clear records eliminate that problem. To illustrate why preparation matters, consider a simplified example. A woman named Maria immigrated to the United States many years ago and kept a small savings account in her home country to support family members. She filed her U.S. tax returns every year but did not realize the account might require reporting. Eventually, she learned about the rules and consulted a professional. With guidance, she corrected the oversight using available procedures and brought her records into compliance. The process took time, but because she addressed the issue voluntarily, the situation was resolved without severe consequences. Stories like this demonstrate that awareness and early action can make a significant difference. Now let us answer a few common questions people often ask about foreign account reporting. First, do these rules affect regular U.S. bank accounts or U.S. Social Security benefits? No. Standard accounts held within the United States and federal benefit payments are not considered foreign financial accounts. Second, what if a foreign account has very little money or is rarely used? If it contributes to totals exceeding reporting thresholds, it may still require disclosure. Third, what about accounts shared with family members? If a person has access to the funds or signature authority, the account may still need to be reported depending on circumstances. Finally, how serious are potential penalties for non-compliance? Penalties vary widely depending on the situation and whether the violation was considered intentional. However, the purpose of discussing these rules is prevention. Understanding the requirements early greatly reduces the likelihood of facing penalties. Before we finish, I want to ask one small favor. If this information helped you understand something new, consider sharing this video with someone who might benefit from it. Parents, grandparents, friends, or colleagues who maintain financial connections with other countries could find this information useful. Many people simply do not know these rules exist. Sharing reliable information helps others avoid unnecessary stress. As we look at the bigger picture, it is important to remember that the purpose of financial reporting rules is transparency rather than punishment. Governments want consistent reporting so that financial records match across systems. When people understand the rules and follow them, they rarely face serious problems. In fact, once you know what is required, compliance usually becomes routine. Make a list of your foreign accounts. Understand whether reporting thresholds apply. Keep clear records and answer tax questions honestly. Small details matter because automated systems review large volumes of information. Preparing early gives you confidence and peace of mind. Waiting until deadlines approach can create unnecessary pressure. Finally, let us summarize the key ideas. U.S. taxpayers may need to report certain foreign financial accounts if their combined value exceeds specific thresholds. These accounts can include more than just checking or savings accounts. Retirement funds, investment accounts, insurance policies with cash value, or certain financial interests abroad may also require evaluation. Government agencies today exchange financial information more efficiently, making accurate reporting increasingly important. For green card holders and future citizenship applicants, maintaining consistent tax records can also support immigration processes. The solution is simple preparation. Identify your foreign financial connections, understand your reporting obligations, gather documentation early, report income accurately, and keep organized records. If you found this video helpful and want updates about financial and immigration topics affecting seniors and immigrants, consider subscribing and enabling notifications. Rules and regulations change over time, and staying informed is one of the best ways to protect yourself and your family. And remember one final point. The information shared in this video is for general educational purposes. It is not legal advice, tax advice, or immigration advice. Every situation is unique, and the rules that apply to you may depend on individual circumstances. If you have questions about your own finances or reporting obligations, consider consulting a qualified tax professional, enrolled agent, CPA, or immigration attorney who can review your specific situation. Always rely on official guidance from the relevant government agencies when making important decisions. Thank you for taking the time to learn about this topic. I am Sofia, and my goal is to help you stay informed, stay prepared, and stay protected. Take care of yourself and take care of your family.